Good afternoon, everyone. Welcome to the latest of Fieldfish's Privacy webinar series. My name is Renzo Marchini, and I am a partner in the Privacy Practice in London. Thank you so much for joining us. Today's webinar focuses on dark patterns and is prompted by the recent publication of guidance on the subject by the European Data Protection Board, the EDPD. My colleagues will explain in greater detail, but put simply, dark patterns are considered, at least by the EDPB, as interfaces and user experiences that lead users into making unintended, unwilling, and potentially harmful decisions regarding to processing of their personal data, all with the aim of influencing behavior and hindering the ability to effectively protect data and make conscious choices. But this isn't just a European concern, and I'm pleased to say that we are joined by colleagues from our Silicon Valley office too, who will give us a US perspective. First up will be Alex DeGay, a senior associate in our team, who will talk us through the EDPB guidance and the Digital Services Act, which has got some relevant aspects. The US side will be covered with a tag team of Andrea Ortega, an associate in our Silicon Valley office, who will talk us through developments at the federal level, specifically the FTC, and then Paul Lenoir, a director from our Silicon Valley office, who will talk to us about state level developments, in particular California and some other states. We will finish within the hour, that is at 5 p.m. in London. Some of you are from further afield. Before we come on to substance, a couple of housekeeping points, please. Do ask questions using the question function on your screen. I may get the opportunity of interrupting my colleagues and putting it to them as they speak, but there should also be time at the end. If we do run out of time, we will respond to questions posed in writing. Next week, we'll send you a copy of our slides and indeed a recording, which will also be posted on our YouTube channel. So there's no need to scribble everything down as we go along. And a couple of other last points before handing over to Alex. Do please subscribe to our blog, which has a regular set of posts on topical issues, and also subscribe to our YouTube channel. And keep an eye out also for other webinars over the coming months. Alex, over to you.
Okay, thank you, Renzo. So I shall take you through the European side of things. So first, a little intro into dark patterns. So the term's been around for a while. It's coined around 2010. And the sort of more simple definition is a user interface that has been carefully crafted to trick users into doing things. There's a Twitter feed where people can upload what they think of as dark patterns. That's where it originally came from. So I put them in three sort of categories. So Renzo, if you wouldn't mind clicking, we'll go on to the first one here. So nudging is what lots of people think of as dark patterns. This is an example from the ICO's guidance. And nudging itself is not necessarily bad. We're using physical or social aspects of a person's environment to influence their behavior. So supermarkets can either put sweets or fruit at kids' eye level by the checkout. If they put fruit and people tend to buy more fruit, that's a positive thing. Gentlemen may notice targets in certain urinals. That's to encourage you to, to make life easier for everyone. The UK government actually has a nudge unit called the Behavioural Insights Team, and they sort of look at ways they can improve behaviour generally throughout the country. So one example was they checked no one was taking up on the offer for loft insurance because they had too much stuff in the loft. So they offered free loft clearing, and then more people got insulation. Sorry, not insurance, insulation. Anyway, so nudging is essentially fine. But what we're talking about here is nudging in the sort of more negative sense. So this is a way of forcing a user typically to make the least privacy protective example. So that can be by prominently displaying one option more than the other. So here in the ICO example, you have a big green accept, that's easy, and then the reject is a small gray link. or having a pre-checked box, or using some emotional language to sort of persuade someone into making a decision you want them to make. So that's the first sort of bucket I consider them into. Then Renzo, if you click one more. Yeah, so this is the second one. This is like keep asking, so you're continuously prompting. So this isn't a real example, but this, you've seen this sort of thing in a lot of services. It'll ask you to add a phone number to your account or add some more personal data on sign on every single time you sign on. So you can click not now or maybe later. You can't say no, or you can say no, but it still asks you. A bit of a war of attrition. And then finally, Renzo, you click one more, the third category, making it harder to cancel. So again, this isn't a real example, but you've seen that sort of thing. So if you have a service and then eventually you want to leave the service, there's often a few, you sort of have to reaffirm that a few times and say, yes, I'm sure, or there might be some emotional language there trying to get you to reconsider. So those are the sort of basic concepts of dark patterns. Now we go on to the next slide. This is the EDP guidance. So yeah, click once more here, and then this is the guidance note Renzo mentioned. It came out in March of this year. There was a consultation period back in May when we thought, let's do a webinar in October around this subject. We kind of hoped the finalized guidance would be published by now. However, it isn't. So we're still basing this on the draft one. So Renzo mentioned the definition of dark patterns from the EDPB, and 2 points to note out in the definition. The guidance is aimed at interfaces and experience implemented on social media platforms that lead users to making unintended or potentially harmful decisions. So it's limited to social media platforms, and you know, in a way, a few of the respondents to the consultation asked, well, why is it just social media platforms? Because a lot of these aspects would apply to any sort of website or app, but that's how it was in the draft. You know, question whether the EDPB will look to that as a basis for non-social media platforms who also use dark patterns, but that's how it's currently drafted. The other point to note is they have very specific terminology, and I couldn't see where they got the wording from. I checked a few sort of academic papers on dark patterns. It doesn't seem to be from anywhere. It seems to be the EDPB's way of categorizing dark patterns. They have 6 categories and then 15 subcategories. And the categories are sort of slightly more detailed than the 3 I mentioned. So it's sort of overloading with too much information, or skipping is when you encourage someone to move over the data protection aspects. Stirring is appealing to their emotions, and there's other ones like that. And then within them, they have these subcategories, and they have slightly weird names like deceptive snugness or look over there, but they do make sense in the context of the guidance. And it's actually very detailed, so it sets out the concept of all these 15, and then in each aspect it goes through, it'll show how a particular design could actually fall foul of several of the subcategories. So that's the sort of terminology you need to get used to. And then the structure is that it's quite well set out, so it sort of follows the life cycle of a typical social media account user. So that's, you know, opening the account, receiving a transparency information, any concerns about security or being asked to check your security settings, how to access your rights, and then finally closing the account. And in each of those, it'll point to several sort of problem areas where dark patterns are usually used, like making it more difficult to close or bamboozling with the transparency information. In each one, it goes through the relevant legal provisions, which is helpful. And also helpful is there are a lot of worked examples, both text-based ones and then some visual ones. So if you are reading it, do it on screen or print out in color to see the effect of, you know, sort of images they're showing. It's quite helpful to have the visual ones. I personally think there could be a bit more. And unlike the ICO guidance I showed earlier, the cookies, they sort of had a good example and a bad example, whereas the EDPB just tended to have like one example, typically a bad one. So that's the setup and the content on a high level. And if we click once more, Renzo, these are my takeaways from reading the guidance. So if you read Article 25 of GDPR strictly, that's the data protection by design and by default, then dark patterns shouldn't arise. So when you're developing the service or the website, you should look to the most privacy protective aspects of it. However, Article 25 in practice is quite vaguely worded, and it rarely ever comes up in enforcement decisions. So I think that the most significant aspect of this guidance is that when they mention the legal provisions, they don't always come back to Article 25. They actually link it to some of the more substantive ones. So they bring it back to Article 5 principles or Article 13 transparency, which are often the basis of enforcement action. So they're sort of saying by breaching this, having this particular design, you're not just breaching Article 25, you're actually breaching Article 5. And I think it's quite a clear message to social media platforms, and anyone who's worked for one of them or even in a marketing team knows that these tiny tweaks to design can make a huge difference. So you're going to have to balance having this clearer new guidance, risk of potential enforcement or reputational damage versus a drop in revenue by tweaking something that means you get a load more users who will not consent or who will leave your service more easily. Okay, Renzo, on we go. Thank you. So I'll just go into a tiny bit more detail around some of these stages of your user journey on the as the EDPB sees it. So in the sign up phase, they warned against that continuous prompting. So provide more data than is necessary. And if you say no, you shouldn't say again. But this is currently very common practice. They also said if you ask for a particular data point for a particular purpose, then you're limited to use it for that purpose. So the example is if you ask a phone number for security, then you can only use the phone number for security reasons. You can't then link it to the other account details or package it and sell it to an advertiser or anything. And that's quite a common practice. And that formed part of some recent enforcement action in the States. And then emotional steering. So that's the example they give of saying, the more you share them, the more exciting your experience will be, alongside a picture of a cute kitten to sort of encourage users to click the sharing option. And then on the transparency side, so we know the regulators take transparency very seriously. They think it's absolutely fundamental to a lot of the other aspects of GDPR. And you have this normal paradox of having to give lots of comprehensive information in a very concise way. So again, they mention layered notices. They warn against vague phrases such as your data might be used to improve our services, which is also very common. And then sort of internal classifications which might not make sense to the average user. So if you call a particular, we use creation data, for example, they use as an example, may not mean anything to anyone who's outside the organization. And then finally, they warned against privacy mazes. So that's requiring users to click on a load of pages that don't really match up in order to find the information they need. And that was a factor in the CNIL fine against Google a little while ago. Okay, so on to the next one, please. So the other areas I thought were worth delving into in the settings part. So the EDPB thinks that the best way to be transparent and give user choice is to have a simple dashboard that the user can easily access at any time and use kind of clear colors there. So, red should be off, not on, and, sliding to the right should be on and the left should be off, by just the standard usage of most users would expect. They also sort of confirm people's opinion of regulators maybe not having great sense of humor by specifically advising against not saying you can't try and be at all amusing, but trying to hide some serious information with humor. So a classic one around cookies. There's an example there about, for delicious cookies, you only need butter, flour, and sugar, but we use cookies too, click here. So they're implying that, in making it amusing and having a link to a real cookie recipe, then no one's going to actually click on the cookies link and see the notice. So no more puns. And then on the closing account part, they're just saying this should be accessible to the user. So no hidden links to close your account. Hold on, you've gone forward, Renzo. There we go. Don't spoil it. It's often the case you need to look quite hard to find how to close an account or check an FAQ page. And emotional staring should not be inflicted at the end. So the example is, think about all your friends who will miss you and so on. And then pausing or deactivating accounts is fine, but it shouldn't be the default option. So if a user still wants to cancel, they should be able to cancel. And then the platform should just make it clear what's happening to their data whilst the account is paused. Okay, so Renzo, click on. That's all we have on the guidance bit, but it's worth mentioning the Digital Services Act.
Sorry, Alex. Before that,
Yep.
we've got 1 or 2 questions coming. So let me take a
Sure.
couple now, specifically about the guidance.
Yeah.
I think you said it was drafted, didn't you? And so a question here is saying, do we have a timetable for when they'll be released?
Nothing I've seen. I was on the page again yesterday. They tend not to say in advance when it will be released unless you check the they announce their meeting agenda beforehand, and then they'll typically say what they're planning on doing at the meeting. So I haven't checked the meeting agendas recently. I mean, it closed in May. The guidance does vary, so some of them are finalized within a few months, but that GDPR scope one that took more than a year to finalize. So it may be that this DSA stuff we're going to talk to has delayed them somewhat to make sure they're aligned, but I haven't heard of an announced date.
Thank you. And then one other one, which you sort of touched upon an aspect of what the questioner is asking here, which is that it is addressed to social media networks, and some consultation comments seem to be about that. But so the question is, I'm not a social network. Do I have to worry about this guidance? I mean, obviously, a lot of our audience today are not social network companies.
So, I mean, I think it perhaps just because they're the obvious targets, and there has been a lot more enforcement action recently, and there's been some huge fines recently. So perhaps they think, well, if we aim it at those guys, it's a more, in a way, it's a safer enforcement action because some of the some of the recommendations are, I think, thinly veiled hints at specific social media networks. And then perhaps there'd be a trickle-down effect. But the guidance is, the title of the guidance is Dark Patterns in Social Media Networks. So unless they, really take those consultation comments in board, at present, it is only directed at social media networks, although I don't really know what the difference is.
Yeah, I mean, what I might add to that, Alex, if I might, is that, I mean, obviously what we're doing in the guidelines here is just applying data protection principles in GDPR. They can't make law, and it shows their what they see as priorities, but they're applying Article 25, they're applying Article 5, and anyone that's applying Article 25 and applying Article 5, which is everyone, of course, ought to have in mind that some regulators will not like some of these patterns, even if you're not a social media company.
Yeah, and that's true. I mean, it does apply, of course, generally. They're not specific. It's, they do talk about signing on to services, but actually it could really be any online service or any app.
Yeah.
And crucially, that brings us neatly back to the DSA, because the Digital Service Act is not limited to social media networks. It's online platforms. Well, it's some other organizations, but relevant for us today, it's online platforms, which is broadly defined. And I think I saw on Twitter earlier, they finally approved the text today. So it's definitely happening. So I haven't read the approved text. I don't think the official version is released, but based on assuming no significant changes since the last version I saw, there is a general prohibition for online services. So the wording here is, its providers of online services shall not design your online interfaces in a way that deceives, manipulates, or materially distorts the ability of recipients, that's users, to make free and informed decisions. So that's all the relevant article actually says. So you'll have to check your online platform, and if you're an online platform, it means it would also apply if you're a very large online platform or very large, search engine. So not the lower ones beneath that. So there's a hierarchy of application. So if you're just a hosting provider, perhaps it wouldn't apply. So, but most sort of publishers, websites, online platforms, this will apply. And the scope of the DSA is very broad as well, so it's extraterritorial. So that's why you should not just ignore that guidance, because there is probably this additional obligation. In terms of examples, so that article is relatively straightforward. There are 3 examples in the recital. So the recital themselves, not legally binding, but they give a flavor of what the legislation was aiming to achieve. And again, they come back to those 3 sort of buckets I mentioned at the beginning. So one is, you shouldn't use exploitative design choices to direct the recipients to actions that benefit you, the provider, but are not in the user's interest. For example, giving more prominence to certain choices through visual clues. So like that ICO example at the beginning. The second one is repeatedly requesting the user make a choice which has already been made. Like I said, keeping asking, sort of get so weary that they're eventually going to say, yeah, fine, just sign me up. And then finally, making the procedure of cancelling a service significantly more cumbersome than signing up to it. So again, that third point we'd mentioned before. So those are the examples, but the unknown quantity is that the DSA provides the Commission with powers to write guidelines on these 3. And I wasn't entirely sure, I'd have to check the final text, whether that applies to all online providers or just the very large ones that the Commission will be, regulating directly. However, we'll have to keep an eye out for that. So DSA, so if it came out today, I think for most services, it's 1st of January 2024 application, although if you are designated as a VLOP, that's 4 months from when that starts. So that's not long at all if you have to check your whole service and make sure there are none of these dark patterns in there. And then one more from me, thank you, Renzo. Yeah, just to briefly mention the children's code from the ICO. So this was known as the Age Appropriate Design Code. It doesn't really talk about dark patterns in particular, and it is aimed at children. However, it does talk about nudge techniques. So any design features which lead or encourage users to follow the designer's preferred paths are not to be used. So there's another clear example: big green yes and tiny gray no, and then some emotional language on the one on the right. So this is sort of assuming it's aimed at a kid. You want to see videos you like or just random rubbish, to encourage them, obviously, to click the personalization toggle. So it's aimed at under 18s. You have to have some way of verifying users if your service may be accessed by them. And I believe the ICO's opinion is if you can't verify a user, you have to assume they're a child. Therefore, you'd have to apply the code in full. The other reason it's worth mentioning is, of course, it was taken up in California, which brings us neatly to introduce Paul, who's dialing in from the States, to talk about the US side of things.
Thanks, Alex. Paul.
Hi, everyone. Thank you very much, Alex. In relation to the US, you have the Federal Trade Commission, the FTC, who is the primary source of legal authority in the privacy and data security space. And so what happens in the US is that the FTC takes action against companies on the basis of Section 5 of the FTC Act, which prohibits deceptive or unfair commercial acts or practices. So there has already been actually quite a number of enforcement actions which have been taken in relation to dark patterns, and those cases were not necessarily privacy related. So as I mentioned, a number of cases have been taken in relation to dark patterns, and what the FTC does is that it's looking for any conduct which it deems deceptive or unfair. So any representation, omission, or practice is deemed deceptive if it is likely to mislead consumers acting reasonably under the circumstances, and it is something which is deemed material to consumers. Therefore, so for example, a misrepresentation in the privacy policy, something on the website or whatever, all of those could fall within the scope of the FTC's powers. And so I mentioned a number of cases have been already introduced. One of the big cases, for example, was in 2020, where you have an online children's education company which had to pay $10 million as part of the settlement with the FTC, and they were also required, to change their billing practices because the FTC considered that the company made misrepresentations about the cancellation, and the company did not disclose as well important information about renewals, how individuals were being charged for memberships without proper consent. So this was already back in 2020, and there were some other smaller cases as well which took place before. And in 2021, the FTC invited comments and hosted a workshop on dark patterns, and it focused more on the particular harms to minors and to marginalized populations. Later in 2021 as well, the FTC released an enforcement policy signaling that it would increase enforcement action to the use of what they call trick or trap dark patterns, which trick consumers into signing up for subscription programs or trap them when they try to cancel. So, really what I'm trying to convey here is that it's not something which is dark pattern is not something which is brand new. It has been something already which has been explored as well by the FTC for quite a while. And even though the focus previously was more on consumer protection, it was more in relation to subscriptions and so forth. What is really important is that the FTC's enforcement policy statements, their workshop and so forth, they did lay the groundwork as well for a broad concept of dark patterns as an unfair and deceptive practice, which is applicable in quite a number of areas, including privacy. Moving on to the next slide, I will pass it on to Andrea.
Hi, everyone. Thank you. So very timely for this webinar. On September 15, 2022, the FTC released a report titled Bringing Dark Patterns to Light, which followed a public workshop that the FTC organized and brought together enforcement agencies, academic researchers, and consumer advocates to share their knowledge of dark patterns, explore harm to consumers, and also analyze how to best address them and eliminate them. So the report also aims to put businesses on notice that the FTC will continue scrutinizing these practices. And more specifically, it identifies 4 common types of dark patterns used across different industries and contexts, such as e-commerce, cookie consent banners, children apps, and subscription sales. So it seems to have a broader scope than the EDPB guidance that we discussed earlier. These 4 categories of dark patterns are design elements that induce false beliefs, those that hide or delay disclosure of material information, design elements that lead to unauthorized charges, and those that obscure or subvert privacy choices. And we'll address each and mention a few examples. So the first one, if you can pass to the next slide, Renzo, please. The first category are, so as we were saying, examples of dark patterns that manipulate consumer choices by inducing false beliefs. And these include using fake news stories to trick consumers into buying, or websites where companies have falsely represented to consumers that its ranking lists, posted consumer reviews, or otherwise endorsed third parties were objective, honest, accurate, and unbiased, when in reality they're based on whether the third parties are paying to be promoted, a personal relationship, or some other connections. Other examples include countdown timers on offers that are not actually time limited, such as the one that is shown on the slide. Claims that an item is almost sold out when there's actually ample supply, and also false claims that other people are also currently looking at or have recently purchased the same product. And you can all probably think of a few examples you've seen of these practices out there, so they're quite common. Now, the point here is that businesses should look not just at the effect their design choices have on sales, click-through rates, or other profit-based metrics, but also on how those choices really affect consumer understanding of the material terms of the transaction. The second category is dark patterns that operate by hiding material information from consumers, such as varying key limitations of the product or service in terms of service documents that consumers don't see before the purchase, or tricking people into paying hidden mandatory fees which are not included in the advertised price or only mentioned late in the buying process. And there's an example of this latter in the slide. The report indicates here that companies should include any unavoidable and mandatory fees in the upfront advertised price, and failure to do so has the potential to deceive consumers in violation of the FTC Act. Relatedly, it also states that companies should also not mislead consumers to believe that fees are mandatory when they're not. And finally, a final point on this second category is that the report notes that companies must make sure their practices don't treat consumers differently on the basis of race, national origin, or another protected characteristic. And also companies whose sales practices target a specific audience, such as children, older adults, or native speakers of other languages, must take into consideration how their claims and design choices will be perceived by these groups. On to the next slide. The third common dark pattern involves tricking consumers into paying for goods or services that they did not want or intend to buy, whether the transaction involves single charges or recurring charges. So this includes recurring payments that are not clearly disclosed, and an example is shown in this slide, or subscriptions that are very difficult to cancel. Another frequent example is when a company deceptively offers a free trial period, but then the trial is followed by a recurring subscription charge if the consumer fails to cancel. In this case, the report notes that companies should ensure they obtain the express informed consent of the account holder to any charges. And notes that here, obviously, acceptance of the general terms of use would not suffice and would not constitute affirmative and ambiguous consent to a particular purchase. And also manipulating consumers into agreeing, by employing these dark patterns designed to subvert their autonomy or impair their decision-making would also not be compliant. On the point of cancellation of charges, it states that cancellation mechanisms should be at least as easy to use as the method the consumer used to buy the product or sign up for the service. So this means that consumers should be able to cancel their subscription through the same medium. And it also means that consumers should not be subject to new offers or similar attempts to save the account that impose unreasonable delays on their cancellation efforts. Okay, so finally, the fourth category, the report addresses dark patterns that obscure consumer privacy choices and what those choices mean. So this means that consumers may be unaware of the privacy choices they have online or what those choices might mean and result in a significant deviation from their actual privacy preferences. So this would include the nudging category that Alex mentioned earlier. Some examples of these include not allowing consumers to reject certain data collection or use, repeatedly prompting consumers to select settings they wish to avoid, making privacy choices difficult to access, highlighting a choice that results in more information collection while graying out the option that enables consumers to limit such practices, and also including default settings that maximize data collection and sharing. And you can see an example of this in the slide. Something that may be worth two final points before we jump to the state section. So in addition to avoiding subverting consumer privacy choices, the report highlights the importance of data minimization measures. It indicates that businesses should collect the data necessary to provide a service and nothing more. And the final point is in relation to the use of leads for marketing purposes. So the report indicates that another variation includes or involves lead generators that convey a false affiliation to manipulate consumers into sharing personal data. So the report indicates that lead generators should be honest and about who they are and why they're collecting consumer information. So if a company represents that they're collecting consumer information for one audience or one specific purpose, they cannot then share it with a different buyer or for a different purpose without the consumer consent. Importantly as well, for those that use third parties to obtain these leads, it notes that these companies should monitor what those third parties are doing on their behalf and ensure that the leads they use were not the product of deception. So that's the summary. The report itself contains very helpful examples with also visuals, as well as visuals of FTC complaints and a compilation of common dark patterns in case anyone is interested in digging more into it.
Thank you, Andreas. A couple of questions, actually, if you don't mind, if I could take if you could take them. I think you touched on this, but it might be worth just clarifying, what is the status of this report? The precise question asked is, have they issued regulations, or is this guidance concerning dark patterns as a, quote, deceptive practice, quote? What is the status? How does this tie into actual US law?
Yes, so this is just, it's not binding, so it's guidance, and it's based on, you'll probably have heard me refer a few times to the FTC Act. That's the act, that the FTC uses to enforce all of these practices so far, which was also, mentioned by Paul initially, I think. But I don't think, I'm not aware of, any potential new regulations focused specifically on dark patterns. It would be so far for now under the FTC Act.
Yeah, thank you. And next question for you. Sorry, I'm not sure if the questioner heard this correctly, but you mentioned that we cannot charge the customer after the trial period, even if they don't cancel the subscription. How does charging them post-trial amount to dark pattern if the terms clearly say they will be charged? I suppose clearly is the important word there, isn't it?
Yeah, if you go to the prior slide, I think there's, you can see here there's kind of a hidden subscription down in red.
Yeah.
So I think that's the type of examples they're looking at. And what I mentioned around the trial is, so it's when a company, offers a free trial, but then the trial is followed by a recurring subscription charge that maybe was not informed initially to the individual or the user, or maybe it just states, if you fail to cancel, then we'll start charging you with subscription charges, and that's what the guidance is looking at.
Thank you.
Basically, yeah.
Great. Thanks, Andrea.
Actually,
and over to Paul to cover state law.
Thank you very much. And just one point I want to add in relation to the previous question as well is, as you mentioned, Renzo, it's really about how clearly it was communicated to the user. So if it was, if the amount which will be charged after the trial subscription is not clearly communicated, like here it's in the small print, the fine print, as the FTC said. Well, that's the issue, because the user may not necessarily be aware of the subscription amount. So that was the key issue.
And Paul, this nicely illustrates the difference also between this guidance and, of course, the EU one, which the EU one focus is really on personal data, but here is much wider, isn't it? Of course, it's consumer protection.
Exactly.
Yeah.
And
right.
That's the reason why in this case it wasn't specific to privacy at all. It was more in relation to subscriptions, but then it could also be applied to privacy. But in any case, even though the FTC's report is, it's not a regulation from the FTC, we do have, in any case, some some laws which specifically mention dark patterns. For example, the California Privacy Rights Act, the CPRA, which is not to be mistaken with the current California law, the CCPA, the California Consumer Privacy Act. The difference being that the CPRA, so then it's the new legislation which will apply from 2023 onwards, and which updates and amends the CCPA. And so what's really interesting as well is that you actually have this legislation, CPRA, which actually does include dark patterns specifically. So you have a definition in the law in the CPRA. It's not that precise, but it does say that dark patterns are a user interface designed or manipulated with the substantial effect of subverting or impairing user autonomy, decision-making, or choice, as further defined by regulation. So you do have this. I appreciate that it's a bit vague. It doesn't provide that much detail, but it does then refer you to the regulations for additional information. And what's also interesting is that in the definition of consent, they do as well refer to dark patterns. So you have the definition of consent. Consent means any freely given, specific, informed, or unambiguous indication of the consumer's wishes, just like the GDPR actually. So you have a similar definition. It does also say that acceptance of a general or broad terms of use or similar document that contains descriptions of personal information processing along with other unrelated information does not constitute consent. Again, something which is not really surprising for those of us who are familiar with the GDPR, because you have similar requirements in the EU. And then it also adds, an agreement obtained through use of dark patterns does not constitute consent. So this is really interesting as well, because basically it is stating now that if there is something which is deemed a dark pattern, then this would negate consent. If we move to the next slides, so we have in the next slide we have the regulations, the text of the proposed regulation, and they do come up as well with another definition of dark patterns. It expands a bit on the definition in the CCPA. So it says now that dark patterns, it's a user interface is a dark pattern if the interface has the effect of substantially subverting or impairing user autonomy, decision making, or choice, regardless of a business intent. So it's really interesting here as well, I would say, because even if you can demonstrate that, well, we came up with this design choice, by the marketing came up with it, and they didn't have any nefarious intent or any such thing. But then this is, this is what they came up with. Well, the regulation is saying, well, that's nice, but then your intent is not relevant. It's still a dark pattern, even though you didn't have any nefarious intent or whatsoever. And so this means that, especially in the context of California law, if you are using what is considered to be a dark pattern to obtain consent, for example, to sell personal information, well, this would mean that the organization would be in a position of never having obtained the consumer's consent to do so because of the dark pattern. So you have those draft regulations, and those are drafts. They're still subject to change. We're still waiting for the final version of the regulations, which may come soon. The final version may be similar to the current regulations. They may not be. We don't know yet. So we have to wait and see. And what is interesting as well is that the draft regulations do provide a number of examples as to what constitutes a dark pattern, and they also give some requirements as well. So one of the requirements which are stated, symmetry in choice. This means that the request, that whenever you design the interface, there needs to be the symmetry in how you present options. For example, in relation to the opt-in of the sale of personal information, if you just provide two choices, for example, yes and ask me later, well, that's not, according to the regulations, that's not symmetrical, because you don't have any option to say no, to decline later. Both options seem to be agreeing to opt in just at a different point in time, yes, and ask me later. So that's not valid according to the regulations. And for example, the request to opt out of the sale or sharing of personal information, this should not require more steps than what is required to opt in to the sale of personal information. When you have a website banner, for example, in relation to the sale of personal information, if you have two choices, accept all and more information, or otherwise accept all and preferences, well, according to the regulations, that's not symmetrical as well, because the option to accept everything is one single step. But then if you have to then go on to preferences and more information, you have to do more clicks. Well, that's, according to the regulations, not symmetrical because more steps are required. So you would need to have, in order to have a symmetrical choice, you would need to have two buttons, accept all and decline all. And so that's in relation to symmetry of choice. And then the second requirement is that you need to avoid language or interactive elements that are confusing to the consumers. And no double negatives. For example, if you have next to the statement, do not sell or share my personal information, you have yes or no. That's considered to be confusing for the consumer. Likewise, if you have a choice where the yes button is more prominent than the no button, for example, if it's larger in size, if it's in a more eye-catching color, or whatever, that's also deemed to be confusing as well, and also does raise issues in relation to symmetry. The third requirement, no language or wording that guilts or shame the consumer into making a particular choice or bundles consent. So, for example, as you may know, in relation to the CCPA, you have requirements surrounding the disclosure of financial incentives. And when an organization offers a financial incentive, if according to the regulation, if you have two options, yes to accept the financial incentive, and no, I like paying full price, or no, I don't want to save money, that is considered to be manipulative and shaming, and therefore would be a dark pattern. And the last requirement, no unnecessary friction to the process to submit a request. That's also that should not come as a surprise, I would say, for those of us who are familiar with the EU requirements as well, because if you do require the user to search or to scroll through various pages or content to locate the mechanism to submit an opt-out request, that would be deemed creating friction. But what is particularly interesting in this requirement is that the regulations specifically mention as well that if you have circular or broken links, if you have non-functional email addresses such as inboxes that are not monitored or that have aggressive filters that screen emails from the public, they may be in violation of the regulation. That's what the CCP regulation states. So if you provide, if your website has broken links, if you have an email address which doesn't work, or if you're not able to, if all the messages go directly into the spam filter, and you're therefore not able to respond to a request from the user, well, according to the regulations, I quote, this may be in violation of this regulation. Likewise, if according to the regulation, if you have a requirement that consumers have to unnecessarily wait on a web page when the business is processing the request, that may be a violation as well of the regulation. Moving on to the next slide.
Thanks, Paul. If you've got maybe a few more minutes, please.
Yeah, I'll go very quickly. If you move to the next slide.
Sorry,
so
trying to. Thanks. Yep.
No problem. Another legislation which also governs dark patterns explicitly is the Colorado Privacy Act, the CPA. I'm not going to go too much into detail for Colorado because there are lots of similarities with California law. So they define in the text of the law as well a dark pattern as a user interface designed or manipulated with the substantial effect of subverting or impairing user autonomy, decision making, or choice. So the definition here is quite similar to what you have in California. And just like in California as well, the definition of consent explicitly excludes agreements obtained through dark patterns. Moving to the next slide. Back in January, the Attorney General already announced that dark patterns would be something which is an area of interest for them, and that they were going to be looking at this issue, and that they're going to potentially adopt rules on this topic. And it just happens as well that so when this was prepared, the regulation hadn't dropped yet, but then now we do have as well the draft regulations of the Colorado Attorney General, which have been published. Those are drafts which are subject to public comments, public hearings, and so forth. So it's not yet finalized, but then those draft regulations as well are really interesting because they do explicitly refer to dark patterns as well. So you have 2 or 3 pages of examples as well as to what are deemed dark patterns, and there are some similarities as well with California law. So that's that's all I wanted to mention today in relation to dark patterns on the state law. You do have as well California did adopt as well a law which is quite similar to the ICO's age-appropriate design code. And in fact, when the law was passed, they explicitly say that this law is modeled after the ICO's age-appropriate design code. So you have something similar which is coming to California. It's not, there's still a little bit of time because it will only enter into effect in July of 2024. And what you do have is that there is as well a reference here to dark patterns in relation to encouraging children to provide information online, which is not necessarily in a privacy-friendly way. So that's all I wanted to mention for today. Thank you very much.
Lovely, Paul. Thank you very much, Paul. I mean, it's fascinating, actually. I don't know too much at all, but I do before today about what's happening in the US. But it's very interesting to me how much cross-fertilization is indeed in your last slide with the age-appropriate design code, but even just sort of definitions of consent. There we go. There are a few questions. So before I wrap, let me see how many we can get through. The first one, Paul, I think is for you. You mentioned CPRA, of course, which referring to dark patterns, but what does that mean for dark patterns under the current CCPA? Permissible?
No, so the CCPA doesn't explicitly refer to dark patterns, and the current regulations as well, they may not refer explicitly to dark patterns, but then they do mention that they do provide some examples which do look a lot like dark patterns. For example, they mentioned that you cannot, a business shall not use a method that is designed with the purpose or has the substantial effect of subverting or impairing a consumer's choice to opt out. That sounds a lot like a dark pattern. So I would say that the CCPA regulations, they do address dark patterns just without mentioning it.
Thanks, Paul. And actually, another one for you, whilst I've got you on the line, is it only California and Colorado? What about other US states, and is it fair game elsewhere?
No, so the the other privacy, the other state privacy laws, they did not explicitly refer to the concept of dark patterns, but then it's very likely as well that they would adopt a similar position, and so they don't refer explicitly to dark patterns, but then again, in the definition of consent or in other areas, they would take into account as well a dark pattern. So I would say that this prohibition against dark patterns, it's something which it's not specific at all to California or in Colorado, that it's US statewide.
Great, thank you. And then I think one for Alex, and then one maybe I'm the last one after that, one for both of you actually. For Alex, I think, has the ICO issued any guidance for UK business? Obviously, you mentioned the Age Appropriate Design Code, which has got sort of nudge techniques expressly mentioned, but there's no other ICO guidance, or is there that I've missed?
There's nothing specific I've seen, and actually I was just checking the data protection by design and by default section of the general GDPR guidance, and there's actually nothing in there.
No.
You'd think it might include there. However, in so checking, I did notice there was a call for views. There was a consultation earlier in summer, which closed in August, and that was for privacy in product design. So they were researching how digital product teams apply privacy by design in practice. So it may be that something comes out of that consultation, because that sounds like this sort of area. But so far, I've seen nothing, and I've heard no announcements about it.
Right. Okay. Good. Thank you. And one for both of you, or maybe just for the EU, but Paul can chip in on US if you will, Andrea. What would you do if you suspected that the service your company provided used dark patterns?
Well, so I've been asked that a few times recently, just because of more because of the DSA prohibition rather than the EDPB guidance. Well, what we're doing at the moment is just I'd say it's a good idea to go have an audit of your service. So perhaps put yourself in the shoes of a user and start a new account and fiddle around with some settings and then close the account and see how many of those stages you notice any kind of nudging technique or deceptive design, and then find the relevant team and discuss how best to avoid it. And there may be some internal pushback if you say, right, we need to turn off all cookies, and then there's one team which gets a lot of revenue from cookies. But that's how we approached it, is actually doing a full inventory of the site. It's quite hard when you kind of know it and you work in it, or actually it was almost easier to come in as an outsider and set up a brand new account and download the app and play around with it a bit, and then just take a series of screenshots and say, well, I think this could be that's using emotional language, or this is being a bit obstructive, or that sort of thing. And then you have at least a list to work through.
Thanks. And last question, and then I'll wrap. Alex, the new EU law, I guess the DSA is meant, does it specify any sanctions for breach? I think I know the answer to that, but you go first.
Yeah, so keep me honest, but yes, it does, and they're whopping. There's nothing specifically on, the EU stuff tends to have a load of articles, and at the end it sets out, well, for these breach of these articles, it's this level of fine maximum, and then for these other ones, it's this level of fine maximum. I believe the DSA goes further than the GDPR, and the fines are up to 6% of global turnover.
That's right.
I think so. I guess there's a less serious one at the 3% level. So I imagine it'll be sort of, if it's parallel to the GDPR, like 15 million euros or 3%, or 30 million euros or 6%. I can't tell you which one the dark pattern prohibition would fall into. I imagine it would be the lower level, but yeah, there certainly are sanctions, but much like the GDPR, there's a couple of years implementation period, and then it'll take a while for the relative regulators to to find like the appropriate level themselves, and they should start with engagement and encouragement before they go straight for the big fines.
Lovely. Thank you very much. And we got timing down to perfection, everyone. Thank you very much to my to Paul, Andrea, and Alex. And thank you, our audience, for joining. I think we answered all the questions. I'll just double check it. If we didn't, then we'll follow up by email over the next week or so. As I said at the top, we'll send slides and a link of the recording very soon. We try and deliver a webinar every month or so. Actually, there's one in 2 weeks' time, on the 20th of October, which was postponed because of the Queen's funeral and the period of mourning. And that's on the metaverse and privacy issues it raises. On the 20th of October, on November the 9th, a webinar on DPO issues, and on the 13th of December, what's now becoming a bit of a tradition, we're going to have a panel of international privacy partners looking back over the last year. So I hope very much that you'll be able to join us for one, if not all three of those. Bye-bye, everyone.